released from the list.
Order number
Same order in 22. Yes. Same order in item number 22.
My lord, item number 6, I am appearing for the petitioner.
Yes.
This matter pertains to arbitration. So, my lord, to
That's CO.
CO.
CO, it is a arbitration matter
From the
arising out of arbitration.
Arbitrator.
So, it may be released to court number 2.
You are for the petition.
I am for the
I
petitioner.
am for the respondent, my lord. In the last circuit, there is an order to place it before court number 1.
By mistake, it has come.
By
It may be
mistake it has
released.
come.
It may be released.
Again,
Petitioner and item number 6, petitioner and respondent are represented. It is submitted that there was an order in the previous bench, that the matter pertains to a revision and application against
Arbitration.
in an arbitration application. A similar order was passed by the earlier bench on June 30, 2025. In next paragraph, in view of the such order, let the matter be released from the list and placed before first court number 1.
court number 1.
Our appearance may be recorded, my lord.
I've already recorded.
My lord.
Grateful now.
Application so what is the seeking first time training instruction of the concerned department. First some adoption deed.
What is the rate petition about?
Adoption.
I have filed an adoption deed to be registered by the authority.
This one accept the registration and adoption of deed of petition dated.
Now they are not registering that on account that the name of the natural mother and the adopting mother is same. Their system is not taking that. This spouse adoption, which is permissible in adoptions.
And the order of the High Court will make it happen. Order of the High Court will make it happen.
Yes, sir. That's how they do it. Even earlier also they did the same.
Petitioner and the opposite party or the respondent? This is writ petitioner, respondent are represented. Stop here. Next paragraph. Advocate for the respondent submits that she has just received the copy of the writ petition and she needs some instruction from the concerned department. Next paragraph. In such circumstances, list the matter on 31st, 28th, 30th on July 30, 2025.
Okay. In the further repetition method. That is not definitely place for next circuit.
Next circuit.
If my lord's is there, I think everybody is not in the
Other side,
living not in the
who is for North and Middle Andaman? The Pudhan Gram Panchayat. Assistant Engineer, Electricity Department of Maya Bandar. Can't you do it in a week?
right. Ineffective in that.
Petitioner, it is submitted on behalf of learned advocate for the petitioner that he is yet to serve upon the respondents. He seeks an accommodation. He seeks the matter to be placed in the next available circuit. And what is your prayer? What is your prayer? You have not gone through. Respond authority to act in accordance with the law. In accordance with what? Writ petition. Respond authority to act according in accordance with. With interest. Next paragraph. It is the matter in the next available circuit as prayed for. In the meantime, petitioner will serve the respondents. Next available circuit. Item number 4. तो यही नहीं है डेफिसिट कोर्ट फी just tackling that order to none appears for the parties. शुरू हो चुके none appears for the party बस हाँ tomorrow देखो तुम
Similar matters are placed before court number 1. In item number 5,
So two matters were there, so code number 1 production has been fixed to them. And we have mentioned that one of the matters is listed here also, so that will be released.
Petitioner and the respondent are represented. Stop here. It is submitted on behalf of the learned advocate for the parties that two matters covering the same issue or between the same parties.
parties are different.
Parties are different. Covering the same issues are pending with the first court. Stop here. In such a view of the matter. In such view of the facts for them, commonly let the matter be released from the list to be placed along with the other matters in the other court.
On the petition, I've applied for 2 days. So, my lordship,
2 days for what?
because we are in the last circuit, we were given opportunity to file supplementary application.
Implement order state for the petitioner to file supplementary affidavit. Yes, sir.
Petition staying in the outstation, because there was no boat, he couldn't reach. So he may come tomorrow. So we say.
After 2 days. By an order dated July 14, 2025, the petitioner was granted liberty to file supplementary affidavit, so, which is yet to be filed. Stop here. Next, it is submitted by an advocate for the land that due to unavailability of votes comma, the petitioner could not travel down to Port Blair to affirm the affidavit. Stop here. She seeks 2 days accommodation. Of the next one. In the circumstances, this is the matter on 30th or 31st? 31st. On July 31.
Yes.
Have you served the other side?
Yes.
Other side served. Nobody is appealing.
Your Lordship, in this matter, senior process. Not surgery for the traditional university. Let the matter be faced on Wednesday, your Lordship.
Wednesday.
Yes,
Have you served the other side?
yes, yes.
Where is the affidavit of service? Madam, there is no track report. There is no track report.
It's fine.
Track report. Track report.
No, your Lordship, Wednesday may be fixed as the filing by.
Let the matter be fixed on Wednesday means 30th. July 30. So the affidavit of service has been filed on behalf of the stop the government. Affidavit of file have been filed on behalf of the petitioner, which does not contain the track report. Petitioner will submit the track report of the date fixed. Sorry. With the track report.
This case was appears for the petition.
Others,
Official responded my lordship. And saying for some exception to file.
that is, since March 21
Keep it as a last chance.
as the last chance. Oh. You are for the petitioner. Petitioner and the respondents are represented. Stop the next paragraph on the prayer made on behalf of the respondent. Please the matter on when? 2 weeks. 2 weeks means beyond this circuit. You have been taking time since March. On next Monday. Monday. On March, August 4th. We have to fix certain matters on Saturday also. Saturday is open.
No.
Yes. Yes, this Saturday is open. On 4th.
Okay.
Item number 10. Not today, for it.
For the rest of the respondent rather than respondent of one, we have filed our affidavit in opposition. But when the petitioner is not appearing from last circuit, the lordship will see the last order.
It was released by the learned judge.
Well, however, they on that day also
Oh,
petitioners.
there is an order that the matter be placed before court number 1.
No, but that is in.
That was that is not required, but that is the order.
No, that is there because Justice Rao used to do matters for the corporate
In-
but now the bench has changed. So
In-
that order is not in force. The circuit has changed.
His lordship has made an order due to some personal reasons. The matter is released from the list of this court. Then said, let the matter appear before Honorable Court number 1.
Yes, but that never happened on that circuit. So now just because circuit has changed, so the lordship can take up this matter.
I can take it.
But petitioner is not a we clear.
And who is for the petitioner?
And for respondent number 1.
You are for respondent number 1, you are rest of the respondents.
Petitioner comes from mainland Nellore and they have been represented, their counsel is Mr. Kishore Datta.
The respondent from giving it to. None appears on behalf of the petitioner. So the current advocate for a respondent and the respondent number 1. Respondent number 1 and current advocate for the rest of the respondents are present. Next paragraph for ends of justice. Let the matter be fixed on after 2 days. 2 days, 28, 29, 30. Fixed on July 30. 30.
But I have drafted, prepared the affidavit, there is even for filing in the one.
You are for the respondent.
Response.
Provision pension. Provision pension has been released. That was the order, sir.
I'll check it with the department, sir.
Considering the initial and the inter alia for a day, pending disposal of the petition, the provision pension may be released to the petitioner in
I'll
accordance
check
with
it
the
with the department and the.
petitioner and the respondent are represented. Stop the on the prayer made on behalf of learned advocate for the respondent. Please the matter on 4th. On August 4th. 4th of August.
For the petitioner husband filed a matrimonial proceeding, divorce for dismissed. I filed maintenance application. In the meantime, the order was passed, then execution was filed, he expired. Department is not releasing pension in my favor. My husband was a government servant. They appeared last occasion and great time to file.
And
I'm seeking an extension to file. The reason is because when his husband has given an affidavit before passing away, that not that I am.
You contested, of course, you were not there, but the divorce proceeding was contested and it was not allowed.
Yes.
So
But
she is the wife.
If it disposed of since the husband has passed away, technically it is instructions.
Well,
So her husband has written affidavit.
marriage subsisted till his death.
But her husband has given affidavit that I'm relinquishing my pensions and all. We have shown the affidavit to put that. The election was passed to file affidavit.
Because in respect of that he is not.
I will system deny the allegiance of and we also the employer grant of from pension or with the respondent use an affidavit.
Department is avoiding this.
By an order dated June 20, 2025, the respondent was granted liberty to use an affidavit. learned advocate for the respondent seeks accommodation for filing the affidavit.
2 weeks, the first extension was that.
2 weeks.
Because they have, department are going to, after drafting, they're going to wait it with their department. Why they require time for.
But then 1 month already in there.
After money,
Or after 10 days, I shall try.
even then it will go out of this circuit.
No, because after 10 days, Saturday is work, so but after 10 days, it will be.
I'm keeping it after a week. Filing affidavit. Stop the next paragraph. Then in such circumstances, list the matter on August 5th of August. A petition is represented upore kore daw. No? 5th August.
Any for the petitioner.
And other side,
And for the respondent, my lord, I think this is appearing for the first time.
let the respondent file a report in response to the. You were directed to file a report in response to the allegations made in the writ petition within a period of 2 weeks from this date.
I can take the date from this part. But this is.
Well, also that I believe that report has already been communicated to the petitioner. Because the petitioner has received a communication from the respondent.
But the lawyer has not been communicated. Huh?
And already an order has been passed in compliance with the direction of this honorable court. As per the last order, the respondent authorities have passed a fresh order.
Fresh order. There is
They were directed to submit the report. In terms of the direction of this honorable court, they have passed them. That has been communicated to the petitioner.
wow. Petitioner and respondent are represented. Study by an order dated July 1, 2025. From the respondent was directed to file a report in response to the allegations made by the petitioner in the writ petition. Study, it is submitted on behalf of learned advocate for the petitioner that the department has prepared such a report and has communicated the same to the petitioner. So the however, learned advocate.
It is actually an order to tell file. It's
Huh?
actually an order. The document which they have handed, but to lordship is an order of.
No, this court has not been handed over anything.
Yes.
There was only a report.
That we.
Short while. You will file. However, learned advocate representing the respondent submits that the document communicated to the petitioner is an order. Stop the. He needs to file a report in compliance of the order dated July 1, 2025. So yeah, he seeks an accommodation. And next further, in such circumstances, list the matter on in when will you file?
But next week,
On August 5th, 5th of August.
Okay, now we see your report moving forward.
Petitioner, the respondent file. Yes,
No, I've already filed.
you have already filed. When did you file? It is not on record. नहीं तो है क्या इसमें कुछ कोई रिपोर्ट है क्या हमारे हाँ एफिडेविटिंग सर्विस है ये तो नहीं रिपोर्ट And who is for the petitioner? No. None appears for the petitioner. Stop the learned advocate for the respondent submits that in compliance of the order dated July 4, 2025, a report has been filed with the department on 23rd of July. Madam, 23rd of July. Has been filed with the department on July 23, 2025. Stop here. Such report is yet to be incorporated with the record. तब ये in such circumstances yes the matter इसको दिखवा लीजिएगा जरा सा रिपोर्ट बोल नहीं फाइल किए हैं तो दिखवा लीजिए list the matter on after 2 days or 3 days Friday on Friday 1st of August. 1st of August.
Now this is the problem as well. But I have this
Have you served? Let petitioner press for letter copy of the served upon the added respondent within a period of 7 days. You were directed to serve upon the added defendants. File an affidavit of service. Where the affidavit of service? On the prayer made on behalf of learned advocate for the petitioner, release the matter on August 1, 2025 to enable the petitioner to comply the order dated July 10, 2025.
I'm dealing with the petitioner. Actually, the petitioner is
Was given the time the operation.
There shall be a stay of operations. It is already, stay is already there.
Pay for their, on inspection and submitting, they are saying they're not going to get the action or they're not going to get action order. On instruction and submitting. And there is a stay also.
So that's one file an affidavit. And when you propose to file affidavit, you were directed to file an affidavit. In how many days?
It's Monday.
4th. Petitioner and a respondent are represented. Stop the learned advocate appearing for the petitioner for the respondent submits that there is already an order of stay passed on July 14, 2025. So she seeks time to file affidavit. So the next paragraph is the matter on August 4th. 4th of August.
My lord, item number 17, I am appearing online, my lord. But I am for the petitioner.
180. And
There was a direction for filing a reply, my lord, to the affidavit filed by the state respondent. I am seeking a time of extension of 2 weeks, my lord, to file the reply once.
You are for the private respondent.
Yes, respondents, I filed my affidavit in August.
And you have not yet filed. You have.
I have also filed.
You have filed.
Sir, they copy.
And he she wants to file a reply.
My lord, kindly allow me to file both the replies together, my lord, on the next bench, my lord.
For you, 30th June 2025, as per.
Petitioner 6 times to file affidavit and reply. Uh, time to time to file affidavit in reply to the affidavit in opposition filed on behalf of respondent number 1 to 8, as well as 9 to 11 and 13 to 17. Is extended for a period of 1 week.
But 2 weeks is better, my lord, because my client lives in Andaman, my lord, and I'm in principal bench hearing. But kindly gives 2 weeks of time, my lord.
Then it will go out of this circuit.
My lord, for gathering all the documents, my lord, I need 2 weeks of time.
For a period of 2 weeks, as prayed for.
Great.
List the matter before the next available circuit.
Okay.
Grateful, my lord.
Opposition, if any, be filed within 2 weeks from date, reply if any be filed within a week, the matter of the hearing of the 3 weeks. And who is for the other side? Can you inform her? Can you please inform her? Keeping it tomorrow? No, it's simply not today. Not today.
Item 19, I am appearing with Mr. Prasad. The electricity matters that are done. They just give a worship on quick background. What happens is in these islands, there are many places which are government lands. There are many places which are forest lands. Now there are people who have encroached on these lands for a long time, or they have encroached for quite some time. So for many years, there was a controversy that whether these people who are living there, whether they have
Should
a
be
right to
extended.
apply for electricity connection. Now this matter in the 2000s, 2010s, at that point of time, it was a matter of some controversy. Then finally, a special bench was constituted, three-judge bench, decided, if I'm not wrong, by member Justice Ashok as a person. Three-judge bench sat, and this was a judgment for Abhimanyu Majumdar. They decided that the question of encroachment is such that if you have the substantive possession of the land, therefore, under the law, they interpreted Electricity Act, they interpreted the rules. They said, yes, you can apply. Thereafter,
You cannot.
You can.
Yeah.
You can apply, but it will not settle any right, title, interest, nothing. But as long as you are there, it is settled possession.
Basic amenities.
And they framed a second question, Article 21. But Article 21 question, they did not answer. They said, since we have dealt with it to this extent in the statutory right, we will not get into the constitutional. Based on Abhimanyu Majumdar, for many years after that, all the benches followed Abhimanyu Majumdar. That if I am not on forest land, if I am on government encroached land, and if I can show those documents, electricity connection will be given without settling any right title. After this, some circulars came out from the electricity department from time to time. The circulars followed Abhimanyu Majumdar. This was 2011. Now, recently, one bench came, a single bench. And then single bench said, no, law has changed because now new JERC regulations have come. Under JERC regulation, there is some requirement. Abhimanyu Majumdar, with greatest of respect, may I say this? Judicial discipline, all that is there, but single bench said Abhimanyu Majumdar is wrong. Though it was a 3-7. Now, a new circular the electricity department tried to rely. That new circular was considered and the single bench sentence. Now the next circuit, another single bench came. That single bench said, I am considering Abhimanyu Mazumdar, I am considering the law. I don't know how another single bench can overrule three-judge bench. Therefore, this is the law. And
Continued with the
Abhimanyu. Now the third bench came. Third bench came and said, Abhimanyu is there. Law is this. I don't know how one single bench changed the law. I agree with the second single bench.
they also
And detailed order was there. Only problem was, in the middle of all this, the circular which the administration was keeping on trying to show, and based on which that first single bench order was passed, that circular was quashed. Suppressing that and relying on that, the state continued to carry on as if that circular existed. Now, this situation was not brought to light of the single benches. So, in the last circuit, Honorable Justice Rao was taking up the matters. He asked me to bring these things on record. Kindly sees in the record, I have filed a supplementary affidavit. Now, in the supplementary affidavit, your Lordship will get an index which has all the evolution from beginning to end, the entire evolution. What is the law? How it is to operate? I have made it very clear. Now, His Lordship said, once and for all, I am going to pass an order which will clarify the entire situation. And you people all follow them. Why? Because these are not orders which will be passed in personal. These are orders which should be passed in red. Because once it is laying down the procedure, that procedure should bind everyone. And the three-judge bench was never overruled by a larger bench. Neither it was referred to a larger bench. So the law has to be one and all, same for one and all. I'm going to lay it down once and. Now, when His Lordship said this, after Lordship heard me in detail, saw the judgment, saw the law evolution, the state said, no, we have to file an affidavit. First, matter adjourned, no order could be passed. Now, by now, they were supposed to have exchanged affidavit with us, we were supposed to have filed reply. Thereafter, no affidavit has come, no one has come. Now, my prayer is, let the matter be heard on law and order be passed.
let it be fixed tomorrow. Please inform the other side,
I will do so.
or we will proceed with it.
Because once and for all, let the law be settled. Otherwise, what happens? With the greatest of respect, in every circuit, your Lordship will find there are a number of electricity matters which come. Now, I must honestly say that this provides for juniors also. This provides for the bar also. Because in any electricity connection, I am given to understand, even if you go and apply in accordance with the judgments, they will say first go and get an order from the High Court. Now what happens? I come to the High Court. The High Court said, well, your application is pending. Let it be considered, disposed of. They will consider, they will say the same thing. Again, I will come. Then the High Court will say, okay, now we are asking them to see whether it can be given or not. Again, they will see, they will say,
I'll try to dispose of in this circuit itself.
I would prefer if your Lordship would take up, they have been given an opportunity to fight.
Yes,
Now tomorrow, if they come and say, I can't fight,
10th of
Well,
July. Oh, that was the 10th of July. That was for 2 weeks. 3 weeks, 2 weeks. The time is yet to elapse.
no, so they have still not filed their reply. 2 weeks was given for
3
reply.
weeks
3 weeks
Three
was
weeks.
given for reply on 10.
from 10th of July.
And what we'll see now, end of this week, we are already on 28. 3 more weeks. The problem here is very simple. Now, I, as a petitioner in this matter, I am trying to set the record straight legally. But at the same time, kindly consider I am sitting in darkness.
Please inform him. We will take it tomorrow or day after, which will be convenient. Day after,
I'm at your Lordship's convenience.
not today. Just not today.
I'm sorry, I have taken your Lordship's time, but I
No,
just
no.
wanted to give the background of the. The-
એવું નહીં. Not to be correct, not to be.
But 22 were civil matters.
22 already
It's number one.
released. So, 20? 3. SIP and 24. On behalf of the
And I am the
petitioner.
respondent in this matter.
23.
23.
And what's for the petitioner?
So, this is the petition.
No, no, we have
This
some-
is the content arising out of the order passed by Civil Judge Senior Division. And we have filed our affidavit of compliance. We have stated that the civil judge, while passing the order, don't have jurisdiction to pass that order. It's not an appeal from public premises, unauthorized tenancy.
And,
That has been made to civil judge senior division,
and-
while in section 5 of that, that act, the power to file an appeal, to right to file an appeal is given before the district judge.
and,
So, that order, technically is known as.
so have you preferred an appeal?
No, from the single judge's order, I don't have prepared an appeal. From the order of the civil judge senior division, I have not prepared an appeal. But after that, what has happened that they again went to the High Court. High Court said you dispose of the matter in accordance with the law. We have disposed of the matter in accordance with the law. They made again another appeal before the district judge. So what we are saying that anyhow in between those orders, that order has not done. The effect of that order has already been lost because what the civil judge.
What was the order?
Order is for order of stay or not from eviction of the petitioner.
Order 39 rule 1 and 2.
Order 39 rule 1. It's actually a appeal, so it will be a stay. Stay upon the eviction is the disposal of the state appeal. But if state appeal has already been disposed of, thereafter we have evicted.
And who is for the petitioner?
Mr. Arul Prasad.
Last time it was through virtual mode, Mr. Shatrudhu Chakraborty.
He is my senior.
Oh, you are for the
I am sorry, just for me.
rest. Oh, for the contemner. Hmm.
And anyhow, we have disclosed that the condition after the order of the.
The alleged contemners are represented. So the none appears on behalf of the petitioner. Next para go there. It is, submitted on behalf of learned advocate for the alleged contemners that that they have already restored the possession of the suit property in terms of the was there any order? Prevailing before the order under order 39 rule 1 and 2.
No, that is after restoration of possession order is after the last order.
You have restored back to the
petitioner. The possession has already been.
to the petitioner.
Already restored the position of the suit property in terms of.
No, in terms of what the other to the petitioners. Stop the circumstances, release the matter. I'm fixing it to day after tomorrow. Please inform the other side if 31st. Not here. No.
But can it be on first day or day after tomorrow? We have some policy.
On 31st. On 31st. Please inform the other side.
24, 59 of 25.
Nobody?
My lord,
Yes, sir.
My lord, I am for the petitioner, my lord, in item number 24, my lord.
And who is for the other side?
My lord, we have served, my lord.
Where is the affidavit of service?
And we are for the respondent,
Yeah.
there is no affidavit of settlement, this has to go back to the judge who has passed the order. So it go back to the final order is.
My lord, Honorable Justice Hiranmoy Bhattacharya has passed an order, my lord, with the order dated
February.
1st of February 2024, my lord,
Uh-huh.
directing the respondents and the petitioner to act accordance with the statutory provisions of law, my lord.
This is the consideration of the beginning for electricity.
My lord, if your lordship takes the page number 29, my lord,
Yes.
that my lord, the 29 page number, running page number 29 says, my lord, that the regulation 104 of the A&N Island Land Revenue and Land Reforms Regulations so and so empowers the concerned Tehsildar to remove any obstacle or encroachment upon any portion of the property in case the petitioners apprehend that any portion of the property may be encroached upon, it will be open to the petitioners to approach the appropriate authority with a representation. If such representation is made, the concerned authority shall consider and dispose of the same by passing a reasoned order in accordance with law after hearing the respective parties whose interests are likely to be affected and to communicate such order to the parties, my lord. My lord, now, my lord, my grievance is, my lord, on twofold. If your lordship sees the earlier page of the order, the first page of the order, page number 28, which starts from the writ petitioners have prayed for issuance of mandamus restraining the private respondent from transferring, alienating, or delivering his right, title, and interest of 23 square meter. Now, my lord, this 23 square meter of land has been earmarked by His Lordship, the Honorable Justice Hiranmoy Bhattacharya, while passing this order, my lord, after considering the submission and the relevant documents as placed before His Lordship while disposing of the writ petition 993 of 2023. Now, my lord, the second fold is, my lord, the representation lodged by the petitioner in the year 2024 has not yet been disposed of in accordance with law without hearing the petitioner, without granting him the opportunity to submit his version. Moreover, my lord, presently the record says that 23 has now been reflected as 223. My lord, here where the cause of action arose, my lord, and your lordship, uh, I beseech before your lordship for your lordship's kind appreciation, my lord.
My lord, first of all, though, this matter will go back to the judge who passed the order. It's the contempt matter, my lord. So it will be released. And the second thing is that I'll take that point before the judge, but my lord, this is matter is not maintainable against the LG. The contemner is Lieutenant Governor has been made contemner while the order is upon the Tehsildar. So this is not maintainable.
Concept application is
On the one fold, they are saying, my lord, that did not your lordship will not hear out the matter. Then they are taking the point of non-maintainability, my lord. I don't know what stand they are
No, this
taking.
Take to the judge to whom this matter will go. Just Hiranmoy Bhattacharya passed the order. So we shall.
that should
My
go.
lord only grants me a liberty, my lord, to place the matter before his lordship, my lord, as the original records are with your lordship at this point of time, my lord. It may be transmitted to the before the honorable court, my lord, so that we can mention the matter before his lordship and take the matter for hearing, my lord.
Directed against alleged violation of an order dated February 1, 2024, passed in WPA 993 of 2023. Passed by a coordinate bench. Okay. The circumstances, the Stephen, 2025 is released, to be placed before the appropriate bench. The issue to take necessary steps for. Yeah, we have directed the bench to take appropriate steps.
I am so grateful, my lord. I'm so grateful.
Or placing the matter
My lord,
before.
kindly, my lord, kindly, my lord, instruction we given, my lord, so that we would be able to mention it in this week only, my lord, and the matter could be taken up for hearing. My lord. Some expedition, my lord.
History.
I'm so grateful, my lord. Deeply obliged. I'm grateful.
Article 25, there are 260 of 129. It's just last 2 minutes left, 2:30. Now today being the first day, kindly spare us. Tomorrow onwards, it will be there. Because these lawyers come at 9 in the morning, after taking breakfast, serial foods and high foods. And as not, we have first Thursday.
And what is the boundary of 230?
After that, from tomorrow onwards, lordship has one of cases. First, today being the first day, lordship, we have not got both. Yes, spare us.
Not today.
Wait.
একবার শর্ট করে লিস্টটা পুরো ডেকে দেন নট টুডে নট টুডে
I think 23, 74, 20,
That's proper.
ডাক্তার নট টুডে নট
I
টুডে
think 27, April of 2021.
জাস্ট
28, yeah, this is 2022.
just call the item number. Let's call the item number.
28, my lord, the lordship will find from the record.
Not today, not today.
No, even tomorrow it may not be possible to take up, just indicate by. This is a matter which I was referring has been referred to mediation and appeal against acquittal.
28.
28.
It is,
Two successive circuit benches have referred the matter to mediation.
it is a criminal appeal.
It is an appeal against acquittal. This man has been acquitted 2 times. 6 times the matter has been heard. Magistrate, sessions, magistrate, high court, magistrate, sessions. Matter has been going on for last 12 years. Now, my question is only this I'm asking myself. Once a bench, because at that point of time, the complainant and accused were both willing to talk and settle this matter. It's not an offense in that sense, it is 354A. But the question here is, once a bench has taken a view that the matter be referred to mediation and taking into consideration 362, until such time as a report comes that the mediation has been held and failed, whether your lordship
We
can
cannot-
review that order.
We cannot proceed.
So that is my question. That is what I'm asking myself. So now that the order has been passed, it has to go, it has to fail, it has to come back, then we can proceed.
Then we can
But
proceed.
otherwise, 362 is a bar because your lordship would be reviewing it. That this is my point.
So, we'll,
So my humble submission would be that let this matter be placed before the registry because the mediation proceedings I understand would be held sometime. Let it be placed, if it fails, it fails. And then the matter can
you
appear
are,
in the next
you are for the
accused opposite party.
accused opposite party, you are for the, you are for the appellant. And who is for,
Sorry, accused respondent.
and who is for the state?
State will be Mr. Kormokar, public prosecutor.
By an order dated March 17, 2025. আচ্ছা তার আগে করে দেবো আপনার appellant and the private
Accused respondent.
respondents are
One, sole respondent.
respondent is represented. Stop the next paragraph by an order dated March 17, 2025 from a coordinate bench directed this the appeal to be placed for mediation. So it is pointed out that such order has not yet been complied. So no report, no mediation report has been received as yet. Stop the in such in such circumstances, let the matter be brought into the notice of learning registrar for compliance of order dated March 17, 2025.
If it fails, it fails. That
And
report will come.
when should I fix it?
We do not know when that mediation is scheduled. So
No, that can't be scheduled Unless it goes, then it will be scheduled.
Be about 2 weeks, it will take 2 weeks or 3 weeks. I have no idea. Seriously.
No, they will issue notices.
So those procedures will be, let it appear in the next circuit in the meantime.
Stop the list the matter in the next available circuit.
I'm appearing Mr. Prasad. Keep.
চট করে ডেকে দেন বরাবর।
29, and then 30, then 31, then 32, and then 33, 34, 34. I'm not on very, this matter is, it's a second appeal. Substantial question has been admitted, before this is ready, this matter is otherwise ready for appeal. So not, let's see matter. Thus, mainly on 2 questions, this substantial question has been formulated, we have in the CPC. This can be taken.
This will be taken up. Both sides, come both sides?
Yes.
We will take it.
Also getting video for tomorrow.
You are for the,
It is a private case of video Solan. Because worship, second appeals are required to be started in the first week. Otherwise, second week it's not possible to place the entire.
day after?
Day after tomorrow, I will inform him. Be ready.
appellant and the respondent are represented. List the matter on 30th.
Fairly at top. Not please. Well, I'm ready. Then 45, and then 46, then 47, and then 48, and then 39, and then 40, and then 41, and then 42. Then 43, and then 44, and then 45, and then 46, then 47, and then 48, and then 49, and then 50, and 51, and 52, and then 54. And 55, and then 56, and item number 56, out for the 100, number 1.
Google India. I pray for it may fix on Monday because they send the affidavit of position from basic to post.
You are for the petitioner.
I'm for the respondent number.
Petitioner is Mr. Manoj.
Sir, I am the petitioner. I am the petitioner.
Yes, sir.
Sir, I am the petitioner.
What have you? What do you have to say?
Yes, sir, I am the petitioner in the matter.
You are for the petitioner. Item number 56.
56.
Sir, I am the petitioner in person in this matter.
You are petitioner in person.
Now for the promoters from Google India.
When you are
Monday, but in the meantime, I
Yes.
get send it from Delhi.
petitioner in person is represented through video conference. Stop here. Respondent. Respondent number 1 and respondent number 4 and 5 are represented. Stop here on the next paragraph. On the prayer made on behalf of respondent number 1. Leaves the matter on 4th Monday. 4th of August. Sir, 4th of August.
Yes, sir.
And then 57, and then 58, and then 59, and then 60, and then 61, and then 62, and then 63, and then 64, and then 65, and then 66, and then 67, and then 68, and then 69, and then 70, and then 71, and then 72, and then 73, and then 74, and then 74.